Hi there. Today's class covers two topics. One is planning for incapacity and the other is powers of appointment. Very confusing because we'll talk about powers of attorney here and powers of appointment in the second half. We just have to live with it. Okay, preparation for lack of capacity includes provisions for financial decisions and for healthcare decisions. Someone's going to make these decisions for you in your old age if you live long enough to lose capacity. I find that very concerning because I like the idea that I can control everything, that I can build up my savings and I can do renovations to the house, I can pick a retirement community for myself. But the truth is, at some point, I may lose capacity and I have to surrender all of my decisions to other people, decisions about where I live, how my money is spent, who my caregivers are, and whether I undergo painful medical procedures, even when I don't understand what those procedures are for. So this chapter is about the planning tools to shape your destiny and avoid the worst fate of all, which is conservatorship or guardianship, as explained on pages 498 and 499. You don't want to be another Britney Spears and get all of the unwanted publicity of being featured in Sitkov's Wills and Trusts casebook, right? Okay, so professional estate planners do all of this. When you have someone in your office getting a will and a trust, it's a good time to suggest to them healthcare directives and appointments of surrogates, because people don't like to think about these things. And once you have them thinking about death, take advantage and get everything done in one go. Money management is the first issue. If a person can't manage all of her affairs, there are at first various informal measures you can take, like giving your adult children or siblings your passwords to your online banking account, but eventually that won't cut it. Someone's going to discover that your sibling is impersonating you, and then you're going to need these tools, such as having your property in a trust or appointing a durable power of attorney. Don't wait too long, because you need capacity to do both of these, and by the time you are incapacitated, it will be too late. So we begin with trusts, revocable trusts. So we've been talking about revocable trusts. We'll talk about them more as an estate planning device. If you have a revocable trust, you're in good shape because the trustee can step in when you lose capacity. So remember, a revocable trust, a self-settled revocable trust, is one that the donor, say her name is Mary, to make this simpler, the donor sets up this trust, she transfers most of her assets to the trust, she names herself beneficiary during her lifetime, she names herself trustee, so in effect, her relationship to the money hasn't changed at all. What's important for the trust as a planning device is, as a planning device for transferring money, is that you also name a successor trustee who will take over at your death. That successor trustee can also take over when you're incapacitated, at which point that person is a trustee and you yourself are still the beneficiary. As the book points out, the main stumbling block is how to determine when the successor trustee should take the finances into his hands or her hands. So how do you decide that the settler is no longer capable of acting? One way is to get the settler to resign when she realizes that dementia is encroaching. Of course, that won't help very much when you're on a respirator. But the other way would be, of course, to allow a doctor to declare the principal as incapable of making his own decisions. The other mechanism is a durable power of attorney. someone holding such a power can do any of the financial management that a principal could do, including the power to amend a revocable trust. So you have to put a lot of thought into your choice of the person holding the durable power. It has to be someone you trust, someone who cares about you, and someone who's good with money. Durable is important. It means that the power of attorney continues after you become incapacitated. Ordinarily, powers of attorney terminate when the principal becomes incapacitated. States differ on the default rule. Is the default rule durable or not durable? So you have to specify that it's durable in the text or in the header. And we'll get to springing powers in just a second. Again, you have the problem of when does the durable power spring, right? So I'll get to that in a moment, and we'll stop here for the next slide. Well, it turns out I talked right through the next two slides. So here I am on the fourth one about springing powers. Okay, so the springing power is an interesting idea that it comes into effect only when you need it. Again, the problem is the trigger, incapacitation, very difficult to define. Again, you could have a doctor declare that you're incapacitated, but that's pretty drastic because actually you don't want to be declared incapacitated. Yes, if you're hooked up to a ventilator, you will admit that you're incapacitated. But if you're just feeling a little, not all there, you don't want to be actually declared legally incapable of managing your affairs. If you trust your power of attorney, this doesn't have to be so difficult. You don't even need a springing one because the person holding the power can take over gradually, right? This person can manage your affairs at the same time that you manage them. He's an agent, he can do things for you, but he doesn't usurp you. And so as you get older, you could have this person take over some of the more tedious tasks. Let's call them tedious and not difficult to grasp because tedious makes it sound so much more voluntarily. And eventually the person holding the power would take over everything. And if the person holding the power is a family member and there's total trust between you, that will work. Now we turn from finances to surrogate healthcare decisions. And here are the instruments for surrogate and end-of-life decisions. The living will is an instruction. No, let me not say it that way. The living will is a series of thoughts, reflections, and instructions about when to stop healthcare when you are terminally ill. The healthcare proxy is the person who will make decisions on your behalf, and a proxy form can give that person instructions as well. Both of these documents or both of these concepts are often contained in the same document. So the living will is, as this slide suggests, where you communicate your wishes regarding end-of-life care. Living wills can take many different forms. They really are basically musings about what is important to you. So they could either be kind of a description of when life is worth living and when life is not living, or they can take the form of lots of different scenarios and how you would respond to each one. Not that any of those scenarios would ever appear, mind you. It's really to give your proxy an idea about what you would find endurable, or when you would want not to continue in this life. So what makes this, I've used this cartoon earlier in my elder law course, but I think it's very funny. And here's what's funny about it, partly that it's so specific. So obviously no living will is going to say, kill me if I have a headache. But in principle, a living will neither use such trivial examples nor specify every little thing and how you want your proxy to react to that. So in a sense, that means that the living will becomes unuseful in itself to a doctor. So a doctor is not going to, in the heat of the moment, read through pages of your philosophy of life. This is a means of communicating to your proxy, and the proxy becomes all important because he's the one who's going to have to make a decision based on circumstances that you could not have foreseen, or at least the combination of circumstances, the treatment, your condition at the time, your state of mind, and so on. Make a decision based on all of that. It follows pretty much directly from what I said on the last slide, that people with living wills and people without them experience roughly the same outcomes. That's because the people forget to bring the document with them to the hospital. After all, it is an emergency. The decision maker doesn't adhere to the directions set out in the living will. The living will or advance directive was a form and didn't accurately reflect the patient's wishes. Or finally, the directive was misinterpreted by a physician or a family member, or they half remembered the instructions. So what I was saying before is that a living will just cannot address the unique, all circumstances are unique, but the circumstances as they come up in combination with the character of this particular patient and his age and his attitudes towards life. So let's move on to the proxy. The healthcare proxy is the one who makes decisions about continuing treatment and end-of-life decisions, especially end-of-life decisions, which are truly values-based. So the doctor can hardly even recommend what choice to make when it comes to extending life for someone who is likely to remain unconscious or perhaps is suffering from severe dementia. And doctors usually, and I'll get to a caveat on that, doctors usually tend to err on the side of extending life no matter what. So the decision to end care has to be made by someone who knows what you consider makes life worth living. That's what I mean by values-based. It's very important to pick someone who listens to you, who cares about you, and who shares your values, because no matter how specific your instructions are in real life, your proxy will tend to do for you what he or she would do for himself in the same circumstances. Okay, that might be an unexpected turn for this part of the narration. I was saying it's very important to pick someone as a proxy who listens to you, who listens to your instructions, but as important to pick someone who shares your values. Because, as I said, when it comes down to it, proxies tend to do what they would want under the same circumstances. After all, you're choosing someone to use his judgment in unforeseen circumstances. You can't spell out everything that happens. And it's good to choose someone who's predisposed to reach the same decisions as you. You have to give that person instructions, but it's impossible for anyone to know, even for himself, how he would balance the misery of particular treatment against the chances that it would extend his health or his life. So there are these tools for communicating your values to your proxy, which is basically the living will, but it's the values that are more important than the specific instruction, right? So writing a letter to your proxy is a good idea. Everything I've said so far is true in normal times, but these are not normal times. And I sent you a article in the New York Times about the increasing need for directives about being removed from ventilators. And that's why I'm feeling a new sense of urgency about teaching advanced planning. And here are various snippets from newspapers that capture that urgency. Coronavirus update, doctors urge people to update their wills, consider advanced directives before the pandemic worsens. And the second one, as deaths from the coronavirus climb, estate planning lawyers said this week that they were noticing a rise in calls from new clients about putting their end-of-life plans in order. That's from the Times. And then this rather spooky one from the Los Angeles Times. Anyone who feels strongly that they would choose to sacrifice themselves for a younger person or one with fewer health complications, that's not you, should update their healthcare directives now. Okay, so I've been looking around for advanced care directives that are less touchy-feely and here is what I really care about in life, and give you something more specific. I found one and then I lost it, but I did manage to copy out a bit before I lost it, and I've posted it for you on Blackboard. It has, it's very short, and with respect to terminal conditions, which is the only bit I copied out, it says if I'm diagnosed as having an incurable and irreversible illness, and if my attending physician and at least one additional physician who has personally examined me determine that my condition is terminal, I direct that life-sustaining treatment, which would serve only to artificially prolong my dying, be withheld or ended, or I direct that it be continued. So that seems to be most pertinent to the situation today, which is one of being on a ventilator when your lungs are so destroyed that you will never really recover and the ventilation just prolongs your life, such as it is. That's the kind of conversation I think people should be having, and it's their proxies who can give those instructions to the doctors. Now, the situation is turning into one in which there aren't enough ventilators, and furthermore, the proxies aren't necessarily present or allowed to be present in the room when these decisions are being, or in the room where the individual is on the ventilator. So it might just be that doctors take these decisions into their own hands and unplug people when the ventilator is needed for someone else. But it would be helpful to your family and especially to your proxy, if he is in a position to make a decision, to know whether how you feel about this specific situation. So you can read the little bit that I've extracted from this, what I thought was a pretty good power of attorney, living will for present circumstances, and maybe I'll find the whole thing before you actually need it.